I want to retain all rights. I don't want to waive any rights.
And it's not really how it works.
The following conversation originally aired on the Eric Brandt Show on January 29th, 2022. Link in the description.
Hello, everybody. How's everybody doing? We're joined here by a gentleman with the moniker Blind Justice. Are you with us?
Hello.
Hey, how are you, sir?
Doing okay. How are you?
I can't complain, you know. I appreciate you taking time out of your day to come talk with me. I'm going to have a few questions. I've got a green reasonable modification in court for persons with psychiatric disabilities from the NARPA 2018 conference covering the screen right now. Thank you for everybody coming in. So what is blind justice to you, man?
Well, blind justice is a concept. It's an ideal. If you look at any busts or statues of Lady Justice, she has a blindfold on, and it's basically espousing this idea that for there to be fair adjudication or judgment, the person doing the evaluation should be impartial, right? Should be free from prejudice, and if therefore blind, and not look at any circumstances other than the facts of the case. Doesn't matter your past or your what you look like, or what you smell like, or what you sound like. Like any of those factors shouldn't be a consideration when having true justice and judging a thing. And I try to espouse that idea. The Blind Justice YouTube channel is a news broadcasting channel that was formed with with those ideals in mind. Simply, if we want to cover the news, let's cover it from the stance of blind justice, of being impartial and just turning on a camera and letting whatever plays out play out.
Right.
Specifically in the realm of government accountability and what's going on with the government, and the people have a right to be informed what's going on in the government, in every branch of the government and in every level of each branch of the government. And I've been the lead anchor and primary investigative journalist for the Blind Justice News channel, and so many people have attributed that moniker to me, and so more people around the planet know me by that moniker, Blind Justice, than they do by the quote-unquote legal name that is in the legal system, that of Michael Nelson. So I would say it's more fair to in practical terms and in all practicality, to when somebody says blind justice, that I respond to it, because it's more people around the world know me that way. More people have addressed me that way than they have any legal name.
Right. So, how would you like me to address you, sir?
However you want. You can call me anything you want.
I won't call you late for dinner. How's that?
All right.
So, the reason that I wanted to go over these reasonable modifications, I want to go through these slides, and I want to know what it's like from your side, and why you would want such modifications, right? Or such, these things, right? And, I want everybody to understand why, these are important. When people are facing legal challenges or anything like that, I want everybody to understand why these things should be granted and why, they're important. And I really appreciate you taking time to come do this with me.
Yeah, thanks for having me on your broadcast. I'm happy to continue to speak
Yes,
out.
Lackluster, we're live. This is completely live. Sorry.
No, you're fine. Yeah, please engage with your audience. This is your show, and I'm
sorry.
I'm here at your request and to
Yeah.
the request of the people to inform them of what is happening with the criminal justice system in North Carolina. And the justice system is criminal. That's why criminal is the first adjective in their name.
Mm.
So yeah, that's to kind of segue into the slide that you have talking about equal access to people with psychiatric disabilities in the courts.
Right.
Like I mentioned, the idea of being able to disseminate information to the public in regards to what the government is doing. Like I think that's an essential right. That's a substantial right for everybody. And every branch of the government, we should be able to know what they're doing, and at every level, right? So
yes.
At the legislative branch, there's C-SPAN, right? And there's like I think it's a 24-hour thing now, right? You can tune into C-SPAN and they have some kind of legislative broadcast of the U.S.
Dude, there's like
legislators doing.
C-SPAN 3 and 4 now, I think.
Yeah, it's crazy, right? So we have that. We have at the state level, we have state broadcasts in the similar state level, right? You can go into state capitals and you can record your legislative hearings and their sessions, right? You can do that at your city level. You can do that at your town. At the county commissioners, right? At the legislative hearings, up and down the spectrum in the United States. Now, what they do in closed session, that's another thing that we may need to try to address at some point. But they do this thing where they go into a closed session so they can try to keep the public from having access to certain information. And sometimes it may or may not make sense. And that's maybe a discussion for a later time. But for the most part, you can get access to the legislative hearings and what the legislators are doing. Right? You don't necessarily have access to them all the time because a lot of times these legislators aren't full time, right? They come in for session and they if they're not in session, then they're out. Who knows, living their best life with great paychecks. And
right.
Then you go to the executive branch and you have even less access for the most part for the executive branch because try to get an interview with the president and good luck, right? They so they pick it's just like the legislators do. They pick their favorite media puppets to grant interviews to get more specific details on behind the scenes and what their thinking is and why they did what they did or why they're making certain decisions, right? But as far as coverage, they call press conferences, and again, they handpick whatever media outlets they want from the executive branch type of thing. Unless they're doing it like on the steps of City Hall, then it's it's public, right? You can show up with your camera, and a lot of guys and gals out there in the community will show up with and try to ask the questions, right? I think Auditing America is the first thing that comes to mind. Like him and what is it? Fake Mike Real News guy that they go out and so they've done really good stuff with that. But again, when you get to more local, governor, you're again good luck trying to get access to the governor's office to get him to answer questions or her to answer questions.
Right.
And then you go down to larger like counties and stuff, you have like county managers, same thing, try to get access to have them answer questions. Like you get stonewalled a lot. And then you go into like larger municipalities or metropolitan areas, like big cities, have mayors that are probably working full-time jobs because it's a political job and they're doing whatever. But other than the big cities, I would say most mayors or town managers or whatever the executive positions are, like they don't necessarily run. It's not a full-time job, right? They have a day job, a lot of them.
Right.
And they don't necessarily get paid to be a mayor, right? At the smaller municipal level. So,
Right.
so again, trying to get access to them if they're never in their office is really hard to do. And that's the executive branch. The other part of the executive branch is the law enforcement, right? And that one's a lot easier to figure out, like how to engage with them because they're everywhere. And
Right.
anytime somebody sees cherries and berries, they can pull up or walk up and start recording. Anytime they hear the siren, they can follow the sound and go to wherever they are and try to keep them accountable on that side. Now, trying to keep them accountable once they go inside their cars that the public pays for, and once they go inside their departments that the public pays for, and behind their locked doors, and that's difficult. That's an area of access that is lacking.
Mm-hmm.
The area of accountability that's lacking, and that's something that I think the community is trying to address. So then we go to the judicial side. The third branch of the government is the judicial side, and what do we have there? Well, some places in the country, right, we have court TV, right?
Right.
Right. Some places
Yeah.
it's broadcast, right, in the courts, right? Some places they broadcast their cases.
dockets.
They do their dockets. They do it on WebEx. They do it on whatever streaming platform, and that's becoming more and more prevalent because of these government shutdowns. But then you go to some places like North Carolina, and even though the Court of Appeals broadcasts on YouTube, at the lower courts, they freak out at the idea of a camera or an audio recording device in the lower courts. Now, I've personally recorded, or let me correct that. I have recordings where I was personally in court in the lower courts in North Carolina of no less than 7, I think, court appearances now.
Mm.
So that would be 4 Superior Court sessions pretrial in a WebEx setting, 1 in person, so that's 5, and then 2 district court trials where I was in person. And so that's 7 different recordings. And I don't know, man, they've been freaking out about the public having access to what is happening in the courts in North Carolina. And it's insane to me because I think you asked me in the interview the other day, like, are courts open? And I don't think the courts have been open in a long time. I think some states, they're doing a better job of making the courts open again because of them, broadcasting and having their court sessions live to the internet so people can just tune in. Just like you can tune in live to C-SPAN YouTube channel, or you can tune in live to their TV station, right?
Right.
You should be able to tune into the judicial side live and find out what is your judicial branch of government doing in your area. Is this something that, like, how do they claim to have consent of the governed if they hide that branch of the government entirely from the people? And I would say it would definitely not be considered an open court system if that's what they intend on doing. And for some reason, the lower courts in North Carolina, at least in Guilford and Rockingham counties, and even some in Wake County, that's what they've done in regards to me over the last couple of years. And so we've been trying to expose that, and little by little, and it's been tricky because they have all the power, or they assume they have all the power, of the state to come after just some little old blind man for daring to to suggest that the courts be open and the public be allowed to know what's going on in the courts.
So you want to take a second? Let's say hi to a few people. Noel
Yeah,
Armstrong,
go ahead.
Lion One, Alexander, Chris Moyer, Colorado People's News, Lion One, Joe B. Lackluster says he's a longtime fan. Marita Gladson, Chris Moyer, Emerald City Transparency, Joe Hodge, Lady Love FTP. Thank you, Word 'em Up TV. Thank you all for being here. And again, this is why the reasonable modifications is so important to me. Is that damn it, man. I mean, it's like trying to walk up and hand a blind man a piece of paper, an affidavit, and say, "Sign this."
Yeah, that's what the judge ordered one of his goons to do Monday in court. Yeah, and he was threatening me. He was coercing me to take that piece of paper, and I was like, Judge, I can't read that. You've already made the accommodation. You've already told me. You've agreed in writing via email before I got here that documents would be sent to me in a way that I could read via email in OCR format. That's the only way I can read documents myself, is with the screen reading software, the technology that was issued to me by the Blind Rehab with the Veterans Affairs, Department of Veterans Affairs. And so he, instead of like just acknowledging that and doing the right thing, he then turns from threatening me to threatening my auxiliary aide, the individual I brought with me to assist me with certain functions pertaining to other disabilities, not my visual impairment. It was never part of the agreement between me and my auxiliary aide for him to act as a visual interpreter, and he knew that. And the judge orders my auxiliary aide to act as an interpreter, and that's in direct violation of a few different parts of the ADA. One is 42 U.S.C. 12203, which is he can't threaten, intimidate, coerce, or interfere with an individual or an individual with a disability or another person that's assisting the individual with a disability in having equal access to the goods or services. And the other part would be it's 28 CFR 35.160 subsection C that says that you can't force, an entity can't force an individual with a disability to bring or use another individual that they bring with them as their interpreter. So I brought that to the judge's attention. He didn't care. He was going to do what he was going to do. So I think you have a slideshow of some sorts, right? Are you still there?
Hey, let me tell you, turning my mute on here. I apologize. The next slide that's in this is the Mental Health Legal Advisories Committee, basically, and it just goes through and tells, it was an independent state agency under the Massachusetts Supreme Court, Judicial Court, and focuses on cases with systematic impact, right? And the thing that gets me about this, is how many they had 10 attorneys/advocates, one AmeriCorps fellow, one Boston University fellow, and 3 administrative/management persons. Do you know anything about the AmeriCorps?
No.
It's just interesting that was listed on there.
Yeah, I'm not familiar with any of these bodies really. Yeah, this is just I think it's just showing the credentials of those that the commission that they have as a committee in the state of Massachusetts to review these things. That they got input by all these different sources that said, yeah, this is what we recommend in order to make the courts in Massachusetts more accessible in the specific area of like mental disabilities.
Right. Wow.
Yeah.
I
So
mean,
this doesn't even cover all disabilities. This is just a specific recommendation for mental disabilities, and it's important because mental disabilities, for the most part, are invisible, right? Like You can't see them unless there's actions or words or
Yeah.
behaviors of the person that then they could indicate there's something there, right? But if they're not
Right.
saying or doing anything and they're just standing there, you can't tell, right? It's an invisible disability.
Right. Yeah. No. And it saddened me to see that when I flipped over to the next one, slide 3, where it says Committee for Public Counsel Services, right? And they do defendants. They do a listing of the criminal justice defense, juvenile defense, representative. Then they get into mental health litigation, and then involuntary commitments right underneath that, and then the very last one underneath that, which is just were our hearings held. So basically, somebody doesn't know English, but were hearings held, right, before this happened, right? And just by looking at this going down, I can understand where they're going with it already.
Yeah, you can go side by side, and then if you want me to chime in, I'll chime in. That way.
Yeah.
This is just a great example of what some states are doing. This is in the state of Massachusetts, where and this was from 2018, where they had an audit done essentially of ADA accessibility in the court system in regards to persons with mental disabilities. And
right.
So this is just a picture of one state trying to identify any flaws in equal access in the courts and the recommendations on how to fix that. There's a good 70-page document about the Washington State and like how they're doing things and what they're doing to try to make sure there's equal access in courts for persons with disabilities. That if you wanted to put in your show notes or something, that'd be a good resource for people too. But North Carolina doesn't have anything like this. North Carolina, when we started, when I first moved to North Carolina in 2019, at the end of 2019, I tried to get access to the foreclosure lists, and those are only housed in the courthouses. Like, they don't post them online anywhere. They're only physical copies, so printed copies, right? Which I'm going to have a problem reading anyway. So I need to, right? I need them to be able to read it. Yeah, I needed them to be able to read it to me, or scan it and send it to me.
Right.
Right. Or make a copy of it myself and then take it back so that I can have somebody that I trust to read it to me. Right. And they wouldn't even let me in the courthouse just for that limited scope, to go to the clerk's office to figure out what houses are available for me to potentially buy for my family. And so they just like, no, you can't come in. You have electronic devices. I'm like, yeah, these are assisted devices, man. Like, and they're like, didn't I have any idea what I was talking about? And once I briefly explained it, then that made sense to them. Like, oh yeah, that makes sense. But we can't let you in. I'm like, why? Like, we have a rule. Okay, what rule? Like, it's from a judge. Okay, have you read it? And they haven't read it. So they're just enforcing a rule that they haven't read, because their rules have exceptions for persons with disabilities, right? If they're using assistive technology. And then it's like, okay, well, this clearly falls under that. Oh, we can't make the decision. Okay, who does? Who's your disability coordinator? Who's your disability coordinator? Let me make that request to them. I'm making the request to you. You're denying it, which is improper and against the law. Okay, let's get your disability coordinator. Well, I don't know who that is. So they're not trained like at every level in the state government that I've engaged with in North Carolina. People were just lacking training all up and down in every branch, all the way up to the Capitol, on how to deal with disabilities, how to make accommodations, who's the designated disability access coordinator, and how to process requests, and how to deny requests, and how to inform the person making a request that there's an appeals process, and how to do that. And like, none of this was disseminated. None of this was, they even knew it. Like, you can go back to the video, like any of the videos, and like they'll either say, I don't know what you're talking about, or just ignore the request for disability coordinator.
Mm-hmm.
Right.
And just flat out and tell you.
So it's a denial.
Reason.
Right. So it's straight up denial without them knowing the law. So they don't know that they're breaking the law. And I'm trying to tell them, stop, you're breaking the law. Stop. Here's the law. You might want to check it out. And they're like, yeah, I don't care. We have all the power. We can break all the laws we want. And so that's where we are today. Is that's pervasive, even up through superior court judges. They just don't have the training. They don't have the knowledge. They don't have the expertise in the law. And that's what the slide that you're playing shows. This shows that the same thing that I'm claiming that I've done in my audit of North Carolina and their ability to be accessible to people with disabilities, I've uncovered the same facts that this body in Massachusetts discovered, that the same facts that the auditing body in Washington State discovered, and I have the same recommendations. Like it's very similar, and so we can go through this, and if you want, you can point out different things. But it's, you know, I'm not. This isn't new. This isn't something that I started. This isn't something that I thought up. Like, this is just basic stuff that's been going on for a long time.
Right. Yeah, man. So I pulled up the one is labeled background, right? And it says, what happens when litigants ask for reasonable accommodations?
Okay.
Right. And they come in and they say, gal, next friend appointments. They give their state code of 208, subsection 15. Court may appoint a guardian, in quotes, for a divorce defendant incapacitated by mental illness. And they define that capital MA. The guardian, double quote, appears and answers in like manner as a guardian for an infant defendant in any civil action, end quote. Stand in the shoes language. I don't know what that means. But
essentially that's an accommodation that can be made for somebody that has a mental disability that renders them incapable of understanding what's going on in the proceeding, and so they can have, as an accommodation, have a guardian be there to stand in their shoes to essentially make those decisions for them.
And then it comes up and it goes to the next part of this, which is no requirement for any medical evidence for this appointment.
Right.
And then no clear method of termination of an appointment. That's scary.
Yeah. So this body found essentially that the judges were very quick to grant this and overrule the autonomy of somebody with a mental disability rather than making other accommodations. Does that make sense? Rather than making the accommodations so that the person can actually feel safe and have mitigating factors so that they can function in whatever the proceedings are.
Right.
If that means they're doing it from home or doing it from a different setting or doing it with all these other accommodations in place, instead of the courts doing that analysis and saying, okay, yes, what are the ways can we accommodate? They were quickly jumping to, no, we're going to assign a guardian to you, and that person is essentially going to stand in and they're going to make all the decisions on your behalf.
Right.
Essentially, it's like court appointed counsel, right?
Right.
Yeah.
So the request for reasonable accommodations in Massachusetts, slide 6. One, geared for more individuals with physical or sensory disabilities. They say ADA coordinators, but no clear administrative process, writing on how to receive a response, right to appeal, etc. No clear judicial process, unclear when and if such requests should be presented to a judge.
Right. So this is like their overall results that they're reporting. Like, it's mainly they're finding that the access it's easier for them to grant access or accommodations when they can see the disability, right? If it's something they can look at, oh, that person's got a white cane, okay, they're visual impaired. Oh, that person's got, big hearing aids, okay, or that person's got a wheelchair or something that's readily apparent. They're saying that they're more likely to make accommodations, whereas, like I mentioned earlier, things that are mental in nature are invisible and require some some listening to the person and an inquiry into, how can we accommodate and which ways can we make the accommodations for you.
And
but it also, I think you also said there's no clear administrative process set out, and that's the same thing in North Carolina. There isn't. It's just North Carolina just says, hey, here's this list of coordinators, and they recommend given 2 weeks notice for North Carolina, given 2 weeks notice to these trying to get contact with these coordinators and say, hey, this is the accommodations I need. But it's not a clear, established procedure, like administrative procedure. It's like, here are these people, good luck contacting them. We recommend you get your request in at least 2 weeks in advance. Now, you don't know that you need an accommodation until you try to go to the services and you're denied access,
Right.
right? Like you would just assume, of course, I'm going to have access to these services,
Right.
and so you show up to try to do the function. If it's court, you try to show up to go to court, and they say no, you can't come in because of your assistive devices, right? Which is what happened with me.
And then say you FTA.
And oh yeah, and I mean it gets, in my case, yes, they kept taking it to the next level, but so you don't know that there's an access problem until you show up. So 2 weeks notice is not reasonable, right?
Mm-mm.
You don't know that there's an access problem until you try to go there and you find out there is an access problem, and then you say, okay, well, let me make a request to get access.
Right.
Yeah, that's
Well,
why
you
the
should have done
ADA.
that.
That's why the ADA doesn't have any time limit requirements on it. It says that their responses to ADA accommodations are to be timely, but it doesn't say that you have to make like timely requests. I don't believe it says that. It may, but it doesn't define it. It doesn't give a clear defined time frame of what that is. Like I think it says you have to make reasonable accommodations. So is it reasonable for a person expecting to be able to get into court to go to court, and then once they find out, oh, the door's being slammed in their face, for them to, at that point, to make a request to be able to go into court like they normally go everywhere in public with their assistive devices? I think that's perfectly reasonable. I don't know about you.
If they got some assistive devices that help them get through their day, I don't see what the issue actually is. I mean, just I don't see what the issue is. So they've got a neat little form here for reasonable accommodations.
Yeah.
It's very simplistic.
Yeah, so like again, there's no standardized process in North Carolina. So I think that's the recommendations. That form was probably a recommendation of this body, saying here, this is what you guys can do to make it simple, make it a standardized thing, make it an administrative thing. That was the recommendation. Was it needs to be administrative, and when does a judge need to get involved? And like you guys need to figure that answer out, because it's not supposed to be judicial. It's not supposed to be handled by judges. They recommend that it be administrative staff in the courts that handle these administrative requests. And same thing with the state of Washington recommends the same thing, because the ADA says this is administrative stuff. Tennessee v. Lane is the Supreme Court case law on this, saying this is an administrative issue. And these judges are just so used to claiming their judicial powers and trying to don the cloak of absolute judicial immunity, where they say, oh, you know what, anything that's a question about anything, I'm going to try to answer it in my judicial capacity. That way I can, if I'm wrong, I'm protected from lawsuit because I'm acting from the bench. And that's just an abuse of power. And that's exactly what's happened in North Carolina, and what Massachusetts said, has been happening in their state as well.
Yeah, and then it goes on to the next slide where it's like request for reasonable accommodations in Massachusetts ? One form geared for individuals with physical or sensory disabilities. ADA coordinators, no clear administrative processes, no clear judicial processes. It's the same. It's a repeat, right?
Right.
And come on, guys, we can do better than this. Seriously.
Yeah.
Right. And then they go through and show some pictures of, amplified brain injury, Braille, a stick figure with a stick, sign language, wheelchair, no hearing, teletype, and closed captioning.
Yeah.
And as soon as I can actually figure out how to do closed captioning, I'll do it for you guys. Okay. Civil rights. The Americans with Disability Act of 1990. Civil rights legislation that prohibits discrimination on the basis of a disability and promotes equal opportunity to fully participate in all aspects of life and employment, participation in programs and services, and access to public accommodations.
Yeah. So there's three parts of the Americans with Disabilities Act. There's Title 1, Title 2, and Title 3. Title 1 pertains to employment.
Yes, sir.
So trying to get a job, and you have some kind of disability, and the employers or the prospective employer says, no, we don't hire people with these disabilities here. Well, if the requirement of the job is something that physically can't be done because of the
Right.
disability without an accommodation, like if there's no accommodation that can be made essentially to ensure that person can do the job, then the employer can basically deny the applicant. But if there are accommodations that can be made in order to ensure that that person can do the job just as well as an able-bodied person, then they shouldn't be denied or overlooked or scored lesser on who gets hired for the job. So that's Title
Right.
1 stuff. Title 2 is public entities, like the public sector, government, essentially, all things government. Title
And on their
3
slide,
is public
sorry,
access. Yeah, Title
go ahead.
3 is public access to everything else. So, and people misunderstand this a lot too, right? What's publicly accessible? Like Walmart is publicly accessible. It's a private company that is open to the public, right? So it's also known as quasi-public property because it may be owned by private, you know,
Private entity.
by private entity, um, but it's opened its doors to the public. So the public is invited to come into the doors, of the facility.
Right.
Same thing with any restaurant, basically anything that's not a membership only club, right? And even
Right.
then, membership only clubs are still invite people to come in as prospective members, right? So
Right.
so that's what public access means. Like if you're having a problem shopping at a store because of a disability, and you make ADA request for an accommodation, they're required to make a reasonable accommodation for you. That's Title 3. Go ahead.
No, I was just going to say on this slide, and it says Title II applies to government programs and services, comma, which include
Yeah.
courts.
Right.
And then it also highlights the fact of the ADA Amendments Act of 2008.
2008. Yeah.
And it says to be protected by the ADA, one must have a disability which is defined by the ADA as a physical or mental impairment that substantially limits one or more major life activities. A person who has a history or record of such impairment, or a person who is perceived by others as having such impairment. The ADA does not specifically name all of the impairments that are covered. And then it gives an exclusions list. Basically, exclusions: the following conditions are specifically excluded from the definition of disability: transvestism, transsexualism, pedophilia, exhibitionist, voyeurism, gender identity disorders not resulting from physical impairments or other sexual behavior disorders, compulsive gambling, kleptomania, pyromania, and psychoactive substance use disorders resulting from current illegal use of drugs. Okay. Note on the language and the disability. Clearly, not everyone who lives with a psychiatric diagnosis is disabled, but you must be disabled or be regarded as having a disability in order to qualify for modifications or accommodations under the ADA.
Yeah, it's interesting when you go and actually read the language of the law. They define person with disability, which you just read. They define a public entity, basically all government, and their subparts. But they don't define what discrimination is.
Mm-hmm.
Yeah, so that is like the catch-all in the ADA, because it says that they're not, shall not. a person with disability shall not be subject to discrimination by any public entity, right? But they don't define what that is, which means that it's wide open, demeaning somebody, belittling somebody, publicly addressing, and this goes, they talk about this in the slideshow a little bit. They talk about how ADA requests should be handled privately, and then they even say ex parte, like if the judge deems they need to get involved with the granting accommodations or denying accommodations, like it's not something that needs to be handled, and you don't need to CC the prosecutor on. And I think on Eric's channel there was a video where a judge directed me to do just that.
Mm-hmm.
Or says, oh, you need to CC the prosecutor and any communications with the trial court coordinator. Well, the trial court coordinator is listed as the ADA, the Americans with Disabilities Act Disability Access Coordinator. So no, this is administrative. I don't need a CC prosecutor on this. This is administrative. This has nothing to do with adjudication of the case.
Right.
And they make that recommendation in Massachusetts, and they make that recommendation in the state of Washington. But the state of North Carolina has no clue about the ADA. They have no idea. They're in such gross violation of the ADA that their heads are going to spin once they realize, when the federal courts get done with them, like how bad it is. Like, and yeah, so there's a good nugget for you, soundbite somebody wants to pull out.
Okay, so they jump over to slide 14. It says reasonable modifications, also known as accommodations. Unlawful for covered entities to refuse to provide reasonable modifications in employment program services, etc., to otherwise qualified individuals.
Right. So they have to make reasonable modifications. Now, in the ADA language, when it's Title II, it's called a modification. If it's Title I or Title III, it's called an accommodation. So they're used interchangeably, but it's supposed to be understood they mean the same thing. Interestingly, like the word modification means to modify something, right?
Right.
To change something. And so, and that's specifically for Title II, for government. And so for government, like I've made ADA requests to modify their policies. For instance, in one county, I said, hey, I need to be able to file documents with the clerk of court. And they're like, yeah, you have the right. Of course, you're a pro se litigant. Of course, you can file documents with the clerk of court. And I'm like, okay, well, I am sending your clerk an email of the documents that I want them to file. I'm not trying to e-file, to be clear. I'm not trying to e-file this. I want the clerk of court to take the email attachment, to print it out, and to file it. Right? So the modification that I'm specifically requesting is not an e-filing. It's an e-mailing. It's in communication. It's a request to modify how you do communications, because they allow you to physically mail your filings in the mail. They allow you to physically walk in and hand the clerk a physical copy. Well, there's problems with both of those for me because of my disabilities. One, they won't give me physical access to the court, so I can't physically go in to the clerk's office. That's how all of this started. So that's not an option for me. Two, for me to be able to physically mail something to the courts, I have to utilize an interpreter, because I can do all the work myself digitally and make sure I have the documents I want in a digital setting. But as soon as I go to print my shit, I need somebody to look at the printed stuff to make sure I printed the right thing, the right version of it, that I don't have like my grocery list in there, that I don't have some other, rant about whatever in there, right?
Right.
And that,
or that printer actually printed what the fuck it was supposed to.
Exactly. And I can't see
failures.
Right. I can't see to verify the physically printed material. Therefore, I have to use an interpreter to be able to mail in documents to be filed. And they cannot force the person with an individual. the individual with a disability to provide their own interpreter. We covered that earlier, 28 CFR 35.160. So I told them that, like, you guys are forcing me to use a person as an interpreter, and you can't do this. And they said, well, we don't care. We're not going to make an exception because, and they said, it's state law. You know, it's the state rule we have with the courts. It's actually, I don't know if they said law. They said it's a rule of the courts, and we can't break this rule of the courts. And so I reiterated, well, no, you misunderstand. Title 2 of the ADA says that you make modifications to your rules and policies and even laws, like so that you make proper accommodations to the person with disability.
Right.
And they just fundamentally do not understand the ADA in North Carolina.
I think that they this blind dude ain't going to tell me what to do. That's what it seems like to me. So they come back and they go qualified individual. Qualified individual with a disability means an individual with a disability who, with or without reasonable modifications to rules, policies, or practices, the removal of architectural, communication, or transportation barriers, or the provision of auxiliary aids and services meets the essential eligibility requirements for the receipt of services or participation in programs or activities provided by the public entity. It's like putting stairs in no elevator.
Right.
It's interesting in this documentation, I keep reading auxiliary aids, right? And in other documentation that I've read, they call them administrative assistants. I think that terminology. Oh, there was a motion. The response to the motion.
Oh, you talking about a judge's order?
Yeah, it was the judge. I think it was the judge's order. Yes, sir.
Yeah. The judge. He used this all on Monday. Judge Albright in Rockingham County Superior Court. He kept saying administrative assistant or personal assistant. Like, instead of using the actual language of the ADA, which is auxiliary aid, which is what I used every time and what I used in my correspondence with him administratively via email and in the court. Like, he just, again, doesn't even know the language, doesn't know the definitions, doesn't know, probably has never read the ADA. He seems like he could care less about equal access in the courts for the people with disabilities. And that was blatantly obvious in the courtroom. And you can hear it in his tone of voice. He was belittling, demeaning, threatening, coercive, intimidating, interfering, like all the way through. And I'm powerless to stop him, you know? Like,
yeah.
Because he has contempt powers and he's got his goon squad ready to pounce.
Right.
And these are the same people that already kidnapped me. They already wrongfully arrested me. They already threw me in jail. They already stripped me of my assistive devices in jail and tortured me in jail. Right. So I'm literally powerless to do anything, trying to advocate for persons with disabilities, at the same time trying to self-advocate, at the same time trying not to get kidnapped and tortured again. Right.
Right.
Very compromised position. Very difficult to try to figure out how to walk that line and what that line actually is.
Yeah, successfully navigated.
Yeah.
So they get under fundamental alteration or undue burden. This one's interesting to me because it comes down, the government entity is not required to fundamentally alter the program or service which the person with the disability is requesting an accommodation. A government entity has the burden of showing that it would be an undue financial or administrative burden to provide certain accommodations.
Yep.
Right. And then it drops down in the very first one. How does this play out in relation to court services?
Yeah.
Who are court users, right? So have you ever sat on a jury?
No.
Okay. I was just curious because that's one of the next
ones.
So
it's interesting though. Yeah, the slide. I think that because I actually read through these slides and they actually are accessible because it reads.
Oh, cool.
Yeah. And
we're on slide 17 then. I apologize.
No, you're good. I mean, I'm not tracking along with you because I can't do the same and be able to talk to you because it cuts my microphone.
Oh yeah.
But I have reviewed these before you've before you're going through it, thanks to a friend who's an ADA advocate who's working on ADA stuff as well, and yeah, it's so who has access to courts? You know, what are the different people that are going to be going into courts? I think that slide covers it, right? It's going to be
the litigants, jurors, witnesses, and attorneys.
Right.
Who are court users.
And each of those groups of users will have basically different functions, like what they're going to do in court, and those different functions would require potentially different accommodations. Sometimes it would be the exact same accommodations would be needed, right? For a visually impaired juror, they're going to need access to the visual information. Well, if there's going to be evidence, right, they're going to need they're going to need a visual interpreter to interpret like what's in the video. If there's pictures, they're going to need a visual interpreter to tell them what's in the picture.
Right.
If there's witnesses, they're going to need visual interpreter to tell them what the body language is, what the facial expression is of the witness, right? So they can try to judge for themselves if those are indicators of this person's being truthful or if this person's being
dishonest,
untruthful. Yeah, if they're trying to hide something, right? But that's for the juror to decide. That's for the visually impaired juror to decide themselves, and not for the interpreter. The interpreter is just giving information. Okay, juror crosses his arms. Okay, juror's rolling his eyes. Okay, juror's red in the face. Juror's looking away. Juror will not look at the prosecutor, right?
Right.
Or not juror, like witness. You know, witness is doing this, right? So that information is essential in a court setting, in a trial setting, and the jurors have a right to that information because they have to determine like how to weigh the evidence. The testimony is evidence, and if that testimony looks like it's coming from somebody who's being dishonest because of their body language, like it's not just the words they're saying, because they're coached, right? They're prepared. Yeah. They made preparations to answer questions. Like they may even in practice
practices and right.
Yeah, the questions and answers, right? So yeah, but you can't practice with the opposition, right? You don't get a chance to practice answering your questions. Like if it's a state's witness, when the defense does cross-examination, you know, that's going to be very telling. Their body language, their facial expression, right? Because you can lead them. I mean, if you've ever seen what is it, A Few Good Men with man, that's a fucking all-star cast in that.
Yeah, I was gonna say, pick one.
yeah, exactly. Pick an actor. Like you don't have to do 7 Degrees of Kevin Bacon. I think because Kevin Bacon's in the movie, isn't he? Is Kevin Bacon in that movie? I can't remember.
Nicholson, Cruz, Moore, Bacon is in the movie.
Yeah. There you go. Like, yeah, but that, I mean, of course it's a movie, so it's theatric. But if it's based, I think it's based on a real story. So like they had no case against this colonel, right? That he ordered the code red, right? But they got him so worked up on the stand because you have this little know nothing, you know, JAG officer that's like just asking him ridiculous, like seemingly unconnected questions, right? But they were, and like he was just trying to poke at him to show like I'm gonna get you, and eventually like his, you know, I'm sure his body language was telling the attorney like, yeah, keep asking questions, keep going, keep getting them, like he's about to pop, he's about to let it all out, yeah, and that's like essential information, you know, that, and anybody can watch that movie and like realize that, you know, like you can't handle the truth, you know, like the
right.
And then he just like goes off and like incriminates himself on this crazy rant, and then immediately they go into protecting the witness's rights, and it's like, you know, and he's like, what's going on? Like, yeah, bro, you're screwed. So yeah, you can go through these groups because I think in the slides it will show like what different functions they play in court. But essentially, when you're talking about visual information or visual impairment, like it doesn't matter which group you're in, whether you're a litigant, whether you're a jury, whether you're a witness, or an attorney. Yeah, like if you're visually impaired and you're going to court and you're in one of those categories, you need access to the visual information in court. That's just so basic, you know.
But a lot of people don't understand how basic that is.
Yeah.
So KenTP said that it says notice they omitted general public spectator so that this isn't even perfect. Well,
Exactly.
yeah.
That's a great comment. And actually, Tin is the one who shared this slideshow with me.
Nice. Thank you, Tim.
Yeah. Yeah. So no, that's a very great comment, because that's not even all the people that have access to court, right? Anybody that wants to go learn about what's going on in court and keep the government accountable, right? The judicial branch accountable, then
Or
they have
just
access
to
to the court.
even learn how it works, right?
Right. Whether
Not
you
even
just want to go and you're curious, you want to learn how it works in case you have to go to court, or
right.
you're just curious, like if this branch of government is running amok and you want to go find out for yourself. Yeah.
Indeed.
Like yeah. That's a great comment.
So the next one comes in, talks about the litigants, people who file a case in the court or who had a case filed against them, need to file pleadings, need to appear in the court, may be deposed in advance of a hearing or trial. So
Okay.
I mean, these are all. Go ahead.
Right. So, and like I mentioned earlier, I'm a pro se litigant in 2 cases pending in North Carolina, and they've one actually. Now this is interesting, because in one of those counties I told you, they denied me the ability, my ADA request to file my documents without without me sorry, on my own. They basically are forcing me to use an interpreter. The other county, Rockingham, the most recent one, they've made that accommodation. Like I've filed all my filings pro se by sending them the attachments in email, and they've printed them off and put them in the case file. So they've made that accommodation one superior court. They're not making it in the other. And the other one is saying, oh, we have this rule of court in North Carolina, we can't do it. So they're not even consistent, right? There's no standardization in North Carolina, which is insane, because it's the same level of court. It's supposed to be the same throughout.
Right.
Everybody's supposed to have equal access. And so that's one of the things, filings, right? And then appearing in court, I think you listed that as one of the things. And the only appearances in court where I was given all accommodations that I requested, minus the visual interpretation, was the 4 times I did pretrial hearings in superior court setting, 2 in Guilford County, 2 in Rockingham County. And I accepted that level of accommodation because there wasn't going to be any witness testimony. There weren't going to be any jurors that I had to voir dire and ask questions. So I didn't need to have the real-time feedback of their body language to see if I think this juror is being truthful or not. And there wasn't going to be any evidence presented. So the visual information in those settings was going to be very minimal. It's going to be like talking to a judge and talking maybe not me talking to the prosecutor, but listening to whatever the prosecutor had to say, and then and that's it. And maybe listening to the attorney that I had at the time that I fired. And those two two of those 4 hearings was him trying to withdraw from being my attorney. So
I'm sorry, those are just amazing to me.
It's crazy, but the scope of those pretrial hearings in superior court was so limited, and there wasn't going to be any evidence presented. There wasn't going to be any witnesses or jurors, that I needed real-time information about their body language and facial expressions to tell me if what they're saying, if their answers are truthful or not.
Right.
It was just mainly me talking to a judge, and then listening to a couple other lawyers talk to a judge, and they granted. And the only way I accepted it was because of that reason, and because they granted the ADA request for reasonable accommodation for effective communication, that I could use my video recording devices so I can take visual notes, so I can get access to the visual information. And on those videos that aired on Eric's channel last night, somebody told me that you could see my body-worn camera was right there during those hearings. So they made those accommodations for court. So I can go back and I can review and the safety of my own home with whoever I deem appropriate. If there's any visual information there that I needed to know for the next hearing. But it wasn't
Right.
a trial. It wasn't a real time. I need to have this information right now to make decisions on how to question a witness or how to voir dire a juror or
Right.
how to, you know, to pull up certain evidence or attack and some evidence from the other side. Like none of that was at play. So I was like, no, this is an okay level of accommodation because I can have time to review this visual information later with somebody that I trust in the safety of my own home, and I can get that information. If there's something that's pertinent, then I can make sure I take note of it and use it in further proceeding.
Mm-hmm.
But trial is a whole other ballgame. Going into trial or even free trial where there's like a suppression hearing where there's going to be testimony and witnesses and stuff like that, then visual information becomes absolutely essential.
Indeed, I mean, seeing a guy roll his eyes right before he answers the question, or not ever looking at the jury, or always looking down, is highly important information. Crossed arms. I mean, it just the list of visual cues. I mean,
Right.
I mean, I just think about playing poker.
Right.
Even like some of the best chess players in the world have visual cues that they're fixing to do something risky, or
right,
that they can't completely internalize with themselves.
Yep.
And they have reactions to it.
Right.
Then it goes on to the jurors. Here we are with the jurors. The exact same. Well, it's not, because the juror has to look at this from a different point, right? I mean, the evidence side of it, something visual, but they're coming at this thing in a completely different way.
Right.
Witnesses.
Yeah. So the same thing for the witnesses. Like if the witness has disabilities, they need to be considered and accommodations need to be made. So like for just harping on the visual impairment, I know this slide shows about mental disabilities. Those should also be considered and accommodations be made for those. Like if they have PTSD or legal abuse syndrome and stuff, and just being in the courtroom is a stressful environment. What's other ways that they can get that testimony in through sworn affidavit, through sworn statement, through deposition, right, in a different setting, and then they can play that deposition in court, and it's valid witness testimony, right? They can do a deposition in a secure environment. There's other ways of making those accommodations for people with disabilities. For the visual one, you're running into the same problem, right? If there's any evidence, if there's a video going on, and you're asking questions of the witness, like, okay, so what part in this video did Sally slap John? Like where were you? And like
and they point, I was over here.
Yeah, like I without somebody telling me what the video is doing, without access to that visual information, like I'm sorry, like you're not gonna be able to engage with the evidence, because that part of the trial is not made accessible to the person with the visual disability.
Right.
Yeah.
And then the attorneys.
Same thing for attorneys. There's I've actually talked with a visually impaired attorney. I think his name is Lightman or something like that, or like Michael or Matthew Lightman.
Okay.
And he's told me where he's run cameras in his litigation, and the opposing party in the litigation didn't know that he was running a camera, and they tried passing notes to each other and just like holding it, like with the note holding up, like so the people at the table can read it, but he can't see what was being done, and so he reviewed that video footage with his visual interpreter, and they pointed that out, like, oh yeah, they were saying this and they were doing this, and so he used that evidence to show that they were acting in bad faith and discriminating against him at the table, and used it to leverage his position with the
Leverage an
judge and
outcome
everything.
that they wanted. Yeah.
Yeah, saying like these guys are dirty and underhanded, and people just don't want to believe that people do this, but this happens so very regular, especially with people with visual disabilities. It happens all the time.
Right.
Yeah.
10TP, this is live. I'm just slow to read some of the comments. Sorry. I'm enamored with the conversation that I'm having with Blind Justice here, Mr. Nelson. So, yeah, man, this is just and dumbfounded all at the same time. So the next one that they show is this case law. Tennessee v. Lane, 2004.
Tennessee v. Lane is the seminal Supreme Court case, and I cite that in my my motion to dismiss
Mm-hmm.
in Rockingham County Superior Court. And yeah, you can keep going. It's so far it's the seminal case. It's where the Supreme Court says that this is a problem. Access to the courts for the persons with disabilities is a major problem in the United States. Access to public services is a major problem for persons with disabilities in the United States. And Congress has recognized this, and now the Supreme Court has recognized this. And so they was basically the other great thing from that case, not just those statements, them ruling that and finding that, it's them saying that the 11th Amendment protections that the states usually get to claim for immunity is not on the table, meaning that persons with disabilities that are subject to discrimination because of access issues, now you can go after these state actors and the states in federal court and sue them because of violations to the 5th and 14th Amendment. And so that's the Tennessee v. Lane case. It's a great case.
Indeed. And then in they have Marriage of James and Christine C., California, 2008.
Yeah, all these other cases, I'm not sure. I haven't done a full analysis of all these other cases yet, but the Tennessee v. Lane case is your top one. I think that's why it's listed first.
Right, and that one, and then this one is the undisputed wife diagnosed with bipolar disorder as a result entitled to accommodations under ADA. The court has to make specific determination of at least one of 3 specifically identified grounds in order to deny the request for an accommodation.
Yeah.
And then they also list Piscaro v. Stern out of California.
Yeah.
Cannot treat the failure to rule as a denial. Would undermine the policy, so they didn't rule on it and treated it as a denial. Huh. Interesting. Then they show Blackhouse versus Doe out of Maine. An individual may submit a request for accommodations to the clerk of court or to the assigned judge, case management officer, or mediator. If the request is one that may impact the way in which the hearing or trial will be conducted, a judicial officer should consider the request.
Right. So that's like an extreme setting or extreme condition where they said then maybe a judge could consider it because they have more experience of how the adjudication case is going to go. But they're saying that case is basically the court said, hey, no, this is administrative. This needs to be handled administratively.
Yeah. And I agree, 10TP. Just like when BJ's case, when the judge just ignored your live request.
What's that in reference to? Did he say something else before that?
They offer to carry. Oh, he's talking in reference to one of them where they offered to carry a man up the stairs. How undignified.
Yeah, that's Tennessee v. Lane. That's the Tennessee v. Lane case. Yeah. And
basically, just like BJ's case, when the judge ignored it, I think he was referring to the fact that on the previous slide, I had made mention where they cannot treat a failure to rule as a denial, right? So
right. Well, I think he's talking about the dignity, the lack of human dignity that the judge was showing me in open court by essentially going through theatrics all day, the morning session and the afternoon session. Like it was just a theatrical show saying, everybody, look, everybody's, I'm going to spotlight this person with disabilities. Look at all the ways that I'm trying to accommodate the man with disabilities. Now hear this. There's this disabled man in the courtroom, and we're making accommodations for disabilities. He doesn't say those exact words, but that's exactly what he was doing. And he's like, for the
Exactly.
record, like he literally said, for the record, Mr. Nelson is using his phone to check his notes because it's a part of accommodation. And he's still
And let me
checking his
ask you
notes.
this real quick. When you're doing that and he's doing that, for the record,
Yeah.
does that help you or hinder you in your trying to listen to your notes?
Well, I already told him before that, when I was explaining how my
Uh-huh.
headset works, that it would be a hindrance because my headset doesn't block my ears. It's bone conduction, and I can only listen to one thing at a time. And that was already an accommodation that was supposed to have been made, is that one person speaks at a time. I informed them, I have to listen to my phone. So it's
Right.
speaking to me. And if you're speaking and it's speaking, I don't hear either. So he
Right.
already knew that. And he did it anyway. And it's very condescending. Like, I didn't know what he said until I think the day later, once I reviewed the audio of court that afternoon. And just so very condescending and demeaning. Like the way he's like, just for the record, we're waiting for the blind man to listen to his notes.
Yeah. No, seriously.
Yeah. So that's right to Tim's point, that it's very what did you say, undignified, and that's
Right.
discrimination. Because discrimination isn't clearly defined. So I would say that's very much falls in the lines of discrimination.
Yeah. Accommodations are variations in the way things are normally done to enable individuals with disabilities to have equal opportunity to participate in court activities. The courts dismissed plaintiff's case for failure to appear without ever considering a ruling on his request for accommodations. Yeah.
Yeah. Yep.
It's just. So in McDonald, Massachusetts, witness made a request normally without standing, but if accommodation request is denied, the right to enter locurity reviewed by a party seeking to introduce the testimony. Oh, dadgummit, I can't double click on it here to select a word. I double clicked on it, it went 2 slides up.
Yeah.
So
Yeah,
Massachusetts.
You can skip through. It's going to go through a lot of case law that they're showing they're showing, here's these different arguments that have been heard around the country in the federal courts. Here's all these different things that have reiterated what the Tennessee Lane Court and the Supreme Court found, that there is an access problem for persons with disabilities in the courts. And so that's why they have all this ammunition saying, here's all these other case laws that we're just going to show different particular areas where there's problems. And then I think they eventually give recommendations. So you can skip ahead if you want.
Yeah, so this one, what does some of the case law tell us, is the title of this one. And one of the starred events, even with the protections of the ADA, courts can find procedural or other biases to deny an appeal. Insufficient findings, improperly submitted requests, insufficient lower court record, and applicable statutes. So there, and I wish I could say that this was unique. Right.
Well, and that's exactly what this brief was. This slideshow was, was.
They have an auditory processing disorder simulation in this thing.
Oh, that's cool.
Yeah, I wish I could play it. But in 2008, the Supreme Court said, hey, we got a big problem with this.
2004, I think it's the Tennessee.
2004. Yeah, sorry. My apologies. 2004. Here we are, 2022.
Yeah.
Huh.
Yeah, and this slideshow is 2018, so this is just 3 or 4 years back, with Massachusetts saying, hey, we've done our own analysis and we're still screwed up. We need to fix this stuff. So keep going, because
Right.
eventually they say like what they recommend and like what they're doing about it.
Let's go on down to the bottom. Okay, the other recommendations.
Yeah, there might go if you go back from other recommendations, there might be something else about what's people.
Standardized forms, including offers of alternative
Back up again.
basis. Best practices
Yeah,
for
start there,
accommodation? Okay.
because this is what they're going to lay out some best practices and then some other recommendations. So go.
Okay.
That's gonna.
Hey, check it out. Number 1, strictly administrative process.
Hey.
Judges and judicial staff are only notified of an agreed upon accommodations. Denials are made in writing and can be appealed.
Right.
Very important there with the appealed. Collaborative process between court and litigant. Denials require offer of alternative accommodations can be grieved. Also strictly administrative process.
Right.
Request can be submitted ex parte to the judge.
Exactly.
Option for submitting a request under seal.
Right. So the request under seal would ensure that any documentation that the court is trying to ask for, like medical documentation, would be sealed, right? So
guaranteed that
the only time in North Carolina where they've asked for any kind of medical documentation was for me to produce medical documentation of
your vaccination status.
No, my mask exemption.
Oh.
And I gave that in Guilford County, and so that's part of but it was given in open court, and I didn't actually want to make it part of the record. I just wanted, like, they wanted to see it, and I was like, yeah, you can see it, and then, can we have it? And I thought that was my only copy, and I actually had a second copy. I'm like, well, I guess I already have a copy. You can have it. So it was included in the public record, and there's a case law. No, it's actually okay, because it's just a medical document from a neurologist saying that, she's saying that I am medically exempt from wearing a mask.
Right.
So, it's pretty basic. But if, what this is saying is that it would be best practice for those things that they can be sealed for that reason, to keep those medical documents protected for the person's privacy and confidentiality.
Right.
Yeah. What else?
I love this one. Detailed rules of court and disability etiquette and FAQs. Like, don't talk when the blind dude's fucking hitting his phone, okay?
Yeah.
Jeez. If it's in his hand, or if he's, well, you can see that he's engaged.
They can see when an attorney is doing that.
Yeah.
Right.
When they're shuffling
literally Monday afternoon, when I was told to be back for court at 3 p.m. I went in there at 2:30 because I wanted to sit and listen to how the judge was doing other cases, and he had a civil case, and he had these two. Well, there's actually at least 3 attorneys on the plaintiff side. It sounded like an older gentleman, and on the defendant side, it sounded like an older gentleman and a younger woman. Now, that's just what it sounded like. I don't know. I didn't ask them their preferences or any of that stuff. So that's what it sounded like. But I could hear them shuffling their paper around when they were trying to each make their argument, when it was their turn to argue to the judge their stuff, right? They're flipping through their book to say, oh yeah, a judge, in our book, in our brief, it's page, hold on, flip. You can hear them flipping through. It's like, okay, it's page 46. Go down to third of the way down, and then he references his notes and he argues. Like, at no point when either of these 3 attorneys were doing that, when I could hear them shuffling through their notes, did the judge interrupt them and make anything for the record saying, let the record reflect that attorney so-and-so is referring to his notes.
I'm dumbfounded to that.
Yeah.
Here's the person willing themselves into the wheelchair. Let the record reflect.
Right.
Or, you know.
Yeah.
Yeah, that's
All right.
just insane.
What else do we got?
Next thing we got is the standardized forms. Offer of alternatives, basis for denial, review by administrator office, further reviewed by a judge.
Right.
Where
So
the
standardized
states,
form is okay, but again, the person can't be required to make the request in whatever the entity says. This is our
form.
standardized form. You have to do this. Right. You
Right.
can make the request any way you want. You can make it in person, on the
Verbal.
phone, in crayon, on some toilet paper. It doesn't matter. You can make the request any way you want. The ADA doesn't specify you have to do it in a specific format. The standardized form is to assist the personnel at the entity to help them ask the questions and get the information that is needed to either grant or deny it.
Right.
Yeah.
10TP says it's discriminatory not to maintain the confidentiality of a request and any supporting documents and replies. I agree. And he says there's a great case out of Orange County, clerk of courts, and where the attorney for his client didn't have equal access to the court clerk docket, and he won and got $10K out of it.
Yeah.
And somewhere up here, somebody wanted to say real-time rate said hi.
Hey, what's up?
And then it goes, appointment of counsel as one accommodation the court could grant, WA rule.
Right. So that's something that they're part of their best practices. Like, if they wanted to, like in my case, I think that's why the judge was trying to redo this thing on the 11th, to find out if I'm competent, and ask me the questions like how old I am, what's my level of schooling, and all this stuff, to see if if I'm under the influence of any pills or substances, and if I have any mental disabilities that prevent me from understanding. And my answers were, again, I said they would be mostly the same, and they were mostly the same. I think the only difference is in Monday's rehashing of that was I said, I've taken vitamins, because he said, any pills, are you, under influence of any pills? I'm like, well, I'm taking vitamins, so that's helping me for my health. But then I also said, for the mental disability thing, I said something like, I forget how I specified it. I said when it affects me when I'm feeling intimidated, threatened, and coerced, essentially.
Yeah.
And so and at different levels. Like I didn't say, I don't think I completely denied the fact that I was being coerced at the time. Just that the level of coercion was, wasn't to the fact that I was completely shutting down. I'm definitely not at the top of my game in a courtroom.
I can
like
believe that.
my game is way better if I'm not in a courtroom where I'm surrounded by goons with guns that I can't tell exactly where they are and how many. And I can't there are no exits. There is no way for me to protect myself against them, right?
Right.
Like, that's definitely not a great place to be. Yeah.
Definitely not strategic. Then they come in with other recommendations. Consideration of accommodations request by a different judge.
Right.
So
and
basically
that
having
would be
another
to
judge
recuse
do it?
himself, to have another judge come in and look at this. A judge that's not going to be hearing the case, that's not going to be in the adjudication of the case, like review it. And after, and this is where the recommendation is, like after it's already gone through an administrative thing, and if they're still trying to figure it out, then they say, yeah, don't have the judge that's hearing the case make this decision, but have a different judge.
Right. Somebody that's completely ex parte of the whole fucking situation.
Right.
Specific individually tailored orders for accommodations with basis for denials, alternatives proposed, considered outside resources. So, if
Yep.
we needed a visual interpreter, we don't have one in the
Yep.
whole place. And there's
Yep.
an online place that is accredited for being able to do it.
Right.
Use it.
Right.
Okay. I mean, I can, I can track with that one. Timing of request at the outset prior to trial, ongoing as needed. Ongoing/as needed basis, specific to discovery, for example, ease of process important too. So
Right.
being
you shouldn't
able
have to
to
jump through hoops. You shouldn't have to be like thrown in prison and have $50,000 taken from you in order to try to get equal access. That's definitely an ease of access issue. And then timing, like you should be able to make them in person, and it says ongoing, right? Like, so it may change. The circumstances may change. I'm like, you know what? Just like on Monday, prior to Monday, the request was for me to use my hat and sunglasses for several reasons. For one, it's recommended by the blind rehab centers at the VA to wear them as a protection from physical obstacles hitting your face or eyes. And secondarily, or for me, it's primarily, I have another condition that makes me photophobic, like sensitive light. That's from the brain damage, and so I can shut down if I'm exposed to bright enough light long enough. And so that was already explained before I even got to court. And I get to court, and the lights are extremely bright, so I put a scarf around my glasses to help offer extra protection. And then he was threatening me and ordering me to take it off. Like, that's an ongoing, accommodation. Like, accommodations are an ongoing process. Like, circumstances are different than what I anticipated. So I made another request, and then he backed off. But
still. So, got a question. It says, ask BJ his opinion on my suggestion to not answer the medical/medication questions and that it's discriminatory.
Yeah, I think there's an argument to be had there that it could be used as discriminatory and prejudice. However, because it's a specific question that they have in their protocol to determine whether or not a litigant is competent, it's a competency question. With determining pro se status, I agree with you absolutely. There's privacy and it is discriminatory. But they don't understand that, and that's just at that stage of the hearing and dealing with them. I didn't think of that at the time, and I don't know, even if I would have thought of it, I don't even know if I would make that argument in court setting because of their threats and coercion, because they were trying to force me to waive rights, like every time, right? So I think that argument
played three times, bro.
Yeah, I think that argument is better saved and used in the federal courts to show, hey, like, you don't have to answer these questions, and you not answering those questions should not and cannot be used against you to find that you're not competent, because then that's discrimination. So
completely is.
I hope that makes sense.
Made sense to me. Importance of the litigant's right to access the process without necessarily prejudicing their substantive case always has to be taken into account when considering how to handle requests for accommodations.
Yeah, well, they just,
I don't see how that can work. I don't see how that.
They murdered that in my case. Is like, they just completely butchered that.
And that brings us to the final slide, which is questions and suggestions. I think the biggest suggestion that I have is, if you're one of those top dog judges, make it suggestive reading to the rest of the judges below you. Make it required reading. I mean, whatever
What's that?
whatever
The
terminology.
ADA or these recommendations or what? What are you saying?
Just anything related to the ADA. I mean, let's just start anywhere, right?
Yeah. Well,
And
so
then
again, like you got to remember, this is in the world where they are presumed to be God, right? Where they've been told and they've been operating. And I'm not saying this to be snarky or to poke fun of them. I'm saying this to try to have the listeners have some kind of empathy for these people that a lot of the people in the community deem as tyrants. Now their actions are tyrannical. That's like I think judgments are to be reserved for actions and not for people, right?
right,
So the actions, I think we can agree are tyrannical, but they're made by people, and people are broken and have flaws, and so we can have empathy for these judges because they've been taught that they have absolute immunity, that they can do whatever they want without consequence, right? The only
right,
consequence that they can have is if somebody appeals their decision and the appellate court comes back and reverses the decision, and so then they get a little stain on their record because they got overturned by a higher judge, right?
right,
So their reputation gets a stain. So it may ruin
right.
their opportunity for career advancement to work at the appellate court or the Supreme Court or whatever, right? So like that's it. Like, but they've been taught and told that they have this carte blanche immunity, this absolute immunity. They can do whatever they want, and they are not used to people going into the courtroom knowing the law, knowing the state law, knowing the federal law, knowing the human rights that they have, and what laws and constitutions are purportedly supposed to protect those rights and
Right.
can articulate them. That is completely foreign to the majority of these people in the courts. And so
Oh,
when
completely.
that happens, it's out of the norm. What's another word for out of the norm? It's suspicious. All right.
Yeah.
So yeah. So they immediately become suspicious that something's going on, right? That oh,
Right.
this person's a little crazy, or this person's on some medication, or this person has an alternative motive. Not that no, this person actually knows the law and actually cares about people and humanity and rights, and is willing to put it on the line, like and that they don't know what to do with that person.
I couldn't imagine why not. They're so status quo being and rack 'em, stack 'em, and bag 'em.
Yeah.
I mean, the one that and it kills me, right? The frustration that I see on people's faces when you tell them, no, I want to retain all rights.
Yeah.
Right. That one statement.
Yeah.
Alone, I've seen change faces multiple times.
Yeah. They just don't understand. Like, they're like, no, that's not how we do things here. Like, we literally have a clip on the channel where the district attorney's office, Stephanie Reese, like my first time trying to go to court in Rockingham County, she's like, well, I have this waiver of counsel. You need to waive your right to counsel. I'm like, no, I'm retaining all my rights. And she goes like, oh, that's not how it happens here. That's not how we do things here. Something to that effect. Like, they just, it's bureaucratic. It's government just doing government stuff and trying to streamline the process, and in that process, crushing as many people as they can. Let me paint a picture for you people listening. And by you people, I mean just people.
Right, fair enough.
Let me try to craft a word picture, right, for everybody that can hear my voice, and hopefully we can get some kind of closed captioning added once this video gets posted or something. But if not, maybe anybody that's very gifted or has connections to people that are gifted for animation can animate this picture I'm going to paint for you. Imagine, if you will, a machine, and we get an opportunity to look at the inner workings of the machine. It's a really big machine, but we're currently zoomed in on a cog. We have one cog in this machine, all right, and it's spinning and spinning. Well, it's spinning because it's connected to another rod or another cog, and then that it keeps getting bigger and bigger. The cogs, as we keep as we pan out and we like zoom up and to the right, like zoom out and the camera pans up and to the right, you have bigger and bigger cogs and bigger wheels and bigger rods that are connected, right? You realize that, man, this is a massive machine. And at the top, at the end of the machine, you have this crazy huge wheel, this crazy huge cog that's rotating. And there's a platform. It's kind of like a plank on a pirate ship. And there's just a line of people that are being lined up. And they get essentially forced off this plank into this cog and they get crushed. Right? And they get put on this line by people that are in police costumes and people that are in judge costumes and people that are in, administrative office costumes, because they're just, here, you have to fill out this form at the DMV office. Here, no, you do it this way. Here, you do that, right? They're just pushing them in this line, right? And they're all they have multiple lines that are segmented out that ultimately will converge into this one line that is a plank that leads people off into this cog to get crushed, to get destroyed by this out of control beast. Now, well, you think, well, how can we stop that from crushing these people? That cog is too big. It's impossible for us to be able to stop that. Well, if you backtrack on how the machine works, like, it's all interconnected. So if we go back to that first little wheel that's spinning, and you see one stick figure goes up and he's like putting a grain of sand on it, and it's not doing anything to stop the cog. It's like, okay, well, he gets a handful of sand and he tries, and it's still not gumming up the work. So then he gets as much as he can carry, and maybe some pebbles, right, and maybe a couple of rocks, and he puts it in there. And well, that's still not enough. He needs other people that help. He needs a few more stick figures to carry what they can carry, to put it in the little cog, and eventually that cog is going to stop. Eventually that cog is going to get gummed up and get blocked up. So if all you can do is be the stick figure that shares a video or tell somebody, hey, this is what's going on with this system, then you are that stick figure that's carrying what you can carry, and maybe you might stop the cog from crushing another person today.
Got some ideas. Yeah,
Well,
here's one from you.
I appreciate you and what you're doing, and how you're how you're acting in that capacity to help people from getting crushed.
Yeah, man. I just, I do what I can. That's here, and this is what it's turned into. Lightning said Judge Albright was attentive to items that had little, if any, significance to the proceedings at hand. He was actively engaged in CYOA.
Right. Exactly.
Yeah. So with that being said, I think this is a good stopping point. I really appreciate your time. I really appreciate everybody in the comments section taking a moment. And y'all have a wonderful day. And we appreciate y'all being here. We'll play the outro and go from there.
Peace.